Hello everyone, this is Tom Fox and I'd like to welcome you to episode 241 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. Today I have with me Bill Shepard. Bill's a partner at Holland & Knight, and Bill is an expert in human trafficking compliance. He talks to us about some of the challenges that you might have in your supply chain you may not even be aware of around human trafficking, what you need to put into your contracts, and how you need to consider this from the compliance perspective going forward. The episode comes in at just under 25 minutes. I'm also pleased to announce the publication of my newest book, Effective Leadership Skills in Compliance, CCO 3.0 and Beyond. It's available on Amazon.com. In this book, I talk about some of the specific tactics and strategies you can use as a leader in compliance. It should really help you in developing your own compliance practice internally, and would be a big help if you're not a CCO and want to try to get some of the skills that you would need going forward. Once again, it's available on Amazon.com. You can either input the title, Effective Leadership Skills in Compliance, or simply my name, Thomas Fox. I hope you enjoy it. Thank you very much for listening to the podcast. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, I have with me Bill Shepard. Bill is a partner at Holland & Knight, and I recently heard him give a talk at the SCCE Utilities and Energy Conference here in Houston, and he wins the award for either the best or the scariest, or perhaps both, talk I heard at the event, because he really opened my eyes to an area of the law that every compliance practitioner needs to know about, that many of us unfortunately have heard of, but that's about it. So, and that's his presentation was human trafficking compliance. So with that introduction, Bill, thank you very much for both your presentation and taking the time to share it with myself and my wider audience-ship.
Well, Tom, thanks for having me, and thanks for everything that you do to help spread the message of compliance through your writing and these podcasts.
So, human trafficking, when many of us think of that, we think of the movie Taken and sexual slavery and all of those kinds of things. And you made clear that certainly is an issue across the globe, but that was not the focus of your talk. The focus of your talk was really about things that compliance practitioners, businessmen, and companies really deal with on a day-to-day basis, and we may not realize it. So kind of with that, could you maybe explain what the government has had to say about this, and then what the federal acquisition regulations tell us about this area?
Sure, Tom, and before I do that, let me give you a little background sort of how I got into this issue, because I think you're right that people think about human trafficking in the images that evokes of slavery, of sex trafficking, and they think to themselves, well, my company doesn't participate in any of that, and how could this possibly be relevant to the good people who work here at our company and even of our competitors who work in our industry? I got into it when I was Florida's statewide prosecutor, and as that of the chief constitutional officer for state enforcement and state government, I ran cases throughout Florida and sort of had my eyes opened to human trafficking, not just the sex trafficking massage parlor cases that you might think of, but labor practices, and whether that was in agricultural setting, or in quarries, or frankly at sea. There were issues that arose and kind of opened my eyes to both the plight of these victims and the real challenge of bringing these cases. What has happened in the years since human trafficking got placed on everybody's modern radar is the federal government has now taken a page from the FCPA playbook and said, we think that human trafficking is a global problem. We think the U.S. should play a major role in stopping human trafficking. And President Obama announced an executive order before the last election in which he said the U.S. government will no longer purchase items as one of the largest procurement entities in the world. The U.S. government will no longer purchase items that are made from slave labor. And to assure that, we are going to require every U.S. government contractor who meets certain criteria, but almost all government contractors do, who have a supply chain outside the United States, to certify that their supply chain is human trafficking free. And we will put this social goal on the legal shoulders of America's companies. And that's now been codified in the FAR, and there are state laws on it, and the UK has also instituted a similar provision to some of the state laws that are out there. So it is an environment that has changed dramatically in the last few years. And I think the risk is that companies and compliance executives around the country and around the globe think of themselves as, well, our company does a great job and we're not involved in slavery. How could this possibly apply to us? Right. And lo and behold, in that packet of documents that your government contracting executives are signing when they're being awarded the new contract, they're certifying that their supply chain is human trafficking free, and that you conducted the due diligence and you have the compliance programs and that you're doing the auditing and meeting the other requirements that are set out there in the FAR. And I just fear that there are companies that have executives who are signing those documents when they're really not doing the deep dive that the FAR requires.
So what is that deep dive?
Well, some of the requirements that are out there that companies have to certify that the employees hold their own documents, so that employees on the other side of the world have absolute access to their travel documents. Those can't be restrained in any way. You have to make sure that your recruiters on the other side of the world who are recruiting local labor are doing it in a way that's compliant, that they are not requiring recruiting fees to be paid, because the FAR looks at that as a form of indentured servitude, that they're not requiring or that in their explanations and descriptions of the work, that there's no sort of bait and switch, that the people are being recruited are being recruited for the jobs that they're told they're going to have, that the housing that's provided, and in some instances housing is provided as part of the employment, isn't substandard. And I think part of the risk when you get into these kinds of gray areas of what is substandard, what is a fair local wage, those are decisions that are going to be made by a U.S. lawyer in the United States, and you're going to present to them background that you have that says, no, this is the standard living conditions in that country. This is the standard wage in that country. And you better be able to document that you've done that comparison and that you've got support to show that, this was not substandard housing. This was not a below market wage. All these sorts of things that are red flags and that are mentioned in the FAR, you need to be able to have run those things down yourself. Then you've also got to be able to provide them a round trip ticket home if travel's involved. They have to have a ticket home. And one of the last things is you've got to have a written contract in the native language. And you say, Tom, maybe some of these people not only cannot read English, but cannot read their native language. What's the purpose of that? Well, the rule is that you have to have a native written language contract for them to have reviewed and signed. And I think if there's a concern that the people can't read it, your recruiter needs to be able to assure you that they've explained it to them.
But one of the things you made clear was, in case anybody who's listening to this thinks that, well, I don't do business with federal government. I'm just a regular old commercial businessman. This doesn't apply to me. You wrested us away from that by talking to us about the California Transparency Supply Chain Act. So maybe if you could switch over to that and tell us what that is and how companies might have to comply with it.
Sure. The California Supply Chain Transparency Act is really a notice requirement. The California legislature, and with the help and support of Attorney General Kamala Harris, put together a statute that requires companies that are California businesses, and you might not think of yourself as a California business. You need to read the definition pretty carefully because, shockingly, there are lots of businesses that are California businesses under the statute. For example, if you've paid compensation of $50,000 or more in California, if you've got real property or tangible property that exceeds $50,000 or 25% of the company's total real property and tangible property. These are qualifying characteristics that would make your company a California company. And if you are a California company, then you have to notify the whole world on your website homepage what you have done and what you are doing to keep your supply chain human trafficking free. The exclusive enforcement in this area is with the California Attorney General. Now, that's who has the injunctive authority. But I think an issue that companies and compliance officers need to work with their legal department to make sure that the legal department and even the board are aware of this risk is that another enforcement component of this is plaintiffs' class action firms.
Right.
When I first was working in this area a few years ago, and the California Transparency Act was being discussed in the legislature in California, and I was tracking it and working with people on the issue, I made a public records request for everybody who was going to be subject to the law, and they said, well, under California law, we can't give you that information because part of this is based on tax records, and so that's private. And I understood that, and I followed that up with a request for anybody who has made a similar request. I wanted to see who else is inquiring about this. And there were a few law professors who presumably were going to write articles. There were NGOs that were focused on the issue. But there were also plaintiffs' class action firms from around the country who had filed for this information because they want to see who has this duty, who has put things out on their website or not put things out on their website, and who might be in a position where, unbeknownst to them or perhaps with their knowledge, their supply chain is tainted by what might fall under international standards or under the FAR standard as human trafficking.
So when you're president, I'm sorry to interrupt you.
No, I was just going to say that, and if they find that defendant, then consumer fraud suits will be filed, and we've seen 2 examples of that already.
Right.
I think we're likely to see more as this spreads.
In your presentation, you also talked about the importance of compliance with human trafficking laws, regulations in other areas, and you listed some criminal penalties from other laws that might affect complying with this law. So I wonder if you might be able to detail some of those for us.
Sure. I think the biggest risk, some sort of jump out to you, smuggling or forced labor prohibitions. But some of the bigger risks that people don't think about is a standard false statements charge. Because when you certify to your procurement officer that your supply chain is human trafficking free, if it's not, and there are emails that show that it's not, or witnesses who will say that the company knew that it wasn't, you're in a situation there where you have a false statement claim. And so regardless of civil penalties or market force penalties through boycotts and public NGO pressure on your product and your company, you'll have executives who could be facing exposure under a 1001 charge or a conspiracy charge for false statements. And I think that could be a very significant risk area that people aren't thinking about off the top of their head.
Bill, in your presentation, you gave two examples of which I would have said this is just really routine labor, but they were very powerful because they showed how far-reaching these concerns could be. And one was in workers at a quarry in Florida, and the second was for folks manning supply boats, which might be used in the oil and gas industry to supply offshore rigs. Could you really tell us about those two examples and why you picked them?
Yeah, sure, I'm glad to. And I think the first example that you mentioned, the quarry here in Florida, the factual scenario in that case is these were licensed seamen from several countries in Central America who had been promised jobs working on a merchant vessel out of Jacksonville. They came to Florida, were met at the airport as a group, put in a van, and instead of being taken to the port where they were going to board a ship, they were taken to a quarry. And they worked in that quarry, no access to their papers, no access to communications, and certainly no prospect of getting back on a boat and doing the job that they thought they were going to do. Now, most of your listeners are thinking, well, our company would never do that, and that's never going to be a problem for us. And I understand that most companies that have a compliance officer also are not doing these sorts of labor practices. But I think what's important to understand about that is that van was a modern-day Amistad traveling down Interstate 95 here in a large county with over 1 million people population and law enforcement, very sophisticated nature all throughout the county and the state. That happened right under our noses, you know. So that's one example that I think is a domestic example and kind of hits home and lets us know we all need to be on our guard. And the other example that you mentioned, I think is really more in line with some of the concerns that global businesses face. They go to a foreign country, they hire a labor recruiter. And the example, a conversation you and I were having, we were talking about support vessels that might work offshore on a rig in the oil and gas field. And those support vessels are manned by local people. Well, they're part of your supply chain, and they're part of how that's extracted, how it's taken to market, and you probably have not done a whole lot of due diligence on who those people are, how they've been hired, what they've been told, what their working conditions are, all the various things that the federal regulations would want you to work on if you're a government contractor. It's a big ask, I realize that. But it's also, frankly, an ask that whether it's the federal government that's looking at it, or sophisticated news gathering organizations or NGOs that are now seeing this as an area that they feel they have a calling to look into, and doing some deep dive investigations themselves. I mean, part of what we saw in the fishing and shrimp industry was driven by a long-term investigation by the Guardian newspaper in the UK. They committed time, resources, staff into an investigation that led to some pretty significant findings that I think are going to continue to have ripple effects, not just on the market, but on companies that are coming out and changing business practices related to those findings, which were first driven by the media and then seconded by a plaintiff's class action firm.
You know, I can certainly see the Office of Inspector General or other appropriate federal investigatory agency wanting to take a look at these issues for companies that lease federal blocks offshore as well. I'm sure those requirements are in those lease obligations.
Well, and I think that you'll see groups like whether it's the World Bank or other groups like that are involved in some of these things that will begin to incorporate some of these requirements into their contracts, and there'll be contractual provisions related to it as well.
Absolutely. Well, I hope that my listeners have gotten just a sense of the fear you put into all of us at the FCCE conference, but I should also make clear that there's an answer to this. Part of the answer would be probably contacting you, but it's also having a robust compliance program around these issues. I wanted to ask, when you're contacted by a client or potential client, is it to help with an investigation? Is it to help to understand their obligations? Is it to put a policy and procedure in place? Is it all of the above, none of the above? How do you get involved in a case?
And that's a good question, Tom. No, when people contact us here at Holland and Knight, it's for one of two things usually. It's because they are newly aware of these requirements, and they want to make sure that their compliance program is up to these modern standards and that they're doing the right thing from the legal standpoint, that threshold legal standpoint. We also work with our crisis communications people here at the firm to assist clients when their compliance program wasn't up to stuff, and whether it's an NGO or some other third party that's taking a look at the matter. And it's so important for companies to get out in front of these issues. There is no real sort of good strategy related to the most egregious offenses and the impact that's going to have on your brand and your reputation in the marketplace. And not just from an immediate sales perspective, but it's a morale issue, it's a recruiting issue, it's an issue your competitors use against you. A short-term cost savings in labor can have just a dramatic long-term impact on your brand, your reputation, and your ability to get work in the future. It's an issue that I think everyone agrees from a moral standpoint no one wants to be a part of. And so that's why companies need to be vigilant, not just to work with us to get their compliance programs up to snuff, but to actually have a robust testing and compliance program where they're auditing themselves and they're auditing these vendors and they're really digging into this to make sure that they are not the poster child for what went wrong in something like this.
I'm really glad you laid out all of those details, because I've come around to thinking that it's not the monetary penalty, it's everything you laid out, starting with reputational damage, starting with what it does to the morale of the employees, but thinking about even recruiting or doing business or customers or competitors, all of those things really, particularly lawyers, don't focus on that calculus when we're assessing what's the risk, but you really laid that out in a very coherent manner. So thank you very much for doing that.
Well, I think part of that is because I see that, I see it from clients, and I think part of our job as lawyers and executives who are trying to help folks be compliant is to not just give them the sort of tools and the instructions of what it's supposed to be, but to help them understand what the risks are and help them be able to explain it and translate those risks to their business clients, right? To the people at the board, to people in the sales department, to the people in research and development who are spending their time trying to come up with some new innovative product that's really going to help push the company ahead. only to have them run into a brick wall because somebody has tried to shortchange things to meet a quota for a quarter.
Bill, unfortunately, we're
it helps us.
We're at the end of our time, but I was wondering if someone wanted to contact you to follow up on anything you've said or maybe hear more about your presentation. Could they email you, and if so, how would they do it?
Sure, that'd be great, Tom. They can email me at william.shepard, which is SHEPHERD, at hklaw.com. It's william.shepard@hklaw.com, or give me a call at 561-650-8338. That's a direct dial right here at my desk. Glad to talk to any of your listeners.
Well, if anyone's listening that has any interest on this area, I had delved into it a little bit, but really this is by far, Bill's presentation was by far the best. But it wasn't just, hey, this is a scary thing. It was, hey, this is scary, but here's the solution. And he laid that out in his presentation in much more detail than he's been able to do in a short time on this podcast. So I would really encourage people to give him a shout, even if it's just to find out more, and certainly if you need some specific help. So, Bill, I hope this is the first of many dialogues we have on this as the law progresses, as your practice grows, and really if you come up with some new and innovative techniques to help companies comply with this area of the law.
Great, Tom. Glad to keep in touch with you on it.
Thank you. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have 2 calls to action for you. The first is if you could rate this podcast in iTunes, I would greatly appreciate it. The second thing is I'm developing a list of questions for my next mailbag episode. So if you have any questions, please email me at tfox@tfoxlaw.com. Also, please don't forget to check out my latest book, Effective Leadership Skills and Compliance, CCO 3.0 and beyond. I think this could be a real help for you in your own compliance practice, whether you're a CCO or hoping to sit in the CCO's chair one day. This is Tom Fox. Thank you very much for listening. Till next week.